26 CR 749 is called the State of Texas versus Christopher Joseph Burkett. That's you?
Yes, sir.
You were indicted here for the first degree felony of aggravated robbery, which means you were facing no less than 5, no more than 99 years confinement in prison or life in prison and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
What is his bond right now?
500,000.
Was he on probation when this happened? It says he was placed on 2-year probation
I believe he was.
for theft. I say misdemeanor theft. The arrest date was 5/30/25, and he was placed on deferred unadjudicated probation for 2 years.
That's correct.
So he's still on probation for that, right? Do you know anything about it? Is your client? You don't know that?
Yeah, that's in county court at law number 3.
What's
And yes, it was 2 years deferred.
okay? So this is alleged to have occurred on or about April 2nd, 2026. At the time he was on probation.
That's in cause number 25 CCCR 2161, disposition date September 22nd, 2025.
Go ahead. Your motion.
Judge, this is just a motion to reduce bond or a request to have that bond reduced. He is young in age. I believe he is 19. He's 19 years old. He does have support with his family here today. He has an aunt in the audience as well as his girlfriend and 2 cousins here on.
Where are your parents?
My mom, her car is missing.
Where's your dad? Your father?
I don't talk to him. I live with my aunt and my grandma.
Okay.
So his household family is present here with him today. It's my understanding that they would all be pitching in to help make the bond due to the financial situation that my client is under currently. I am appointed to him. He is indigent. He does not have any felony criminal history, does not have any felony criminal convictions, nothing like that. We are asking that since he is local to the community and has a family to support him, that he have a bond that is reasonable for him to make. Any conditions added to that the court believes necessary, we would be happy to abide by.
What state say?
Judge, you accurately pointed out that he's on probation whenever this was alleged to have occurred, and all the conditions of a probation they're easy enough to follow. You commonly say we all have to do those things, but clearly he hasn't been able to do that. So it means that he won't be able to follow any terms and conditions of a bond if he can't follow the probation rules. I'm checking, Judge, but I see that he also has, in addition to this offense, looks like an additional resisting arrest and interference with public duties. I want to confirm that if you'll give me a moment, but the bottom line is, even the facts of this particular offense itself, for the safety of the community, warrants the $500,000 bond. I would ask that you not change it. If your report doesn't show it, he does have juvenile history as well, Judge. I'm in the process of confirming the other arrests.
Why are you doing that? Court has reviewed the public safety report of the defendant that was printed July 2nd. And it does state, among other things, that the defendant is currently on probation for theft and was on probation at the time of the event. Here, this first degree felony of aggravated robbery, which the elements in this indictment state, while in the course of committing theft of property, the defendant intentionally and knowingly threatened and placed the complainant in fear of imminent bodily injury or death, and that the defendant used or exhibited a deadly weapon, namely a firearm. Keeping in mind that this is in course of committing theft, that he threatens to harm another person with bodily injury or death, and the defendant is on probation for theft at the time he's doing this. The probable cause affidavit states that the defendant stole the complainant's firearm. The complainant attempted to retrieve his firearm, but the defendant pushed him, then shot the gun toward the ground near his feet. The complainant was not struck, and the defendant was located nearby. He was taken into custody to speak with authorities. The defendant is alleged to have stolen a firearm from someone, and then when that person attempted to retrieve the firearm, the defendant shot the firearm toward the ground near the complainant's feet. We've got a violent crime alleged, a first-degree felony of aggravated robbery. Under the penal code provides that you're looking at up to life imprisonment. That's how serious this is. You're currently on probation for theft. You are alleged to have, according to this grand jury, while in the course of committing another theft while on probation, then committed this offense of aggravated robbery, which was threatening or placing someone in imminent bodily injury, in fear of imminent bodily injury or death by using a deadly weapon, namely a firearm.
Judge, I've handed you the PC that goes along with the two misdemeanor offenses that are charged and pending against him that arise from March 19th of 2026.
Let me just ask this, there's been no disposition on these?
No, it's pending.
Okay, well,
And the reason why the
why would
state gives that to you,
what
Judge,
do you want
is
me to do with this? Since I'm kind of sensitive about the presumption of innocence.
it's more conduct that's alleged to have occurred while he's on probation.
I know, but there's
And-
been no finding yet.
No, sir.
Okay.
No, sir.
Anyway, putting this aside, putting that part aside, the court finds from the public safety report and the circumstances of this crime, this is serious. You're on probation, then you're out committing crimes that can result in life in prison, where someone could be killed. As it says, you place this person in fear of imminent bodily injury or death. What kind of person does that? You're theft, you're a thief, and you're threatening to kill people. You find that safe for the community? Do you? You don't have to. So you don't have to answer. I'm answering for you. No. Those are the kinds of folks who are a risk to the freedoms and enjoyment of peaceful living of others. The court finds that the bond is high and is warranted under these circumstances. So I'm not changing it. Period. What do we do next?
Can we have an announcement in 4 or 5
Yes,
weeks,
ma'am.
Judge?
Yes, you may. Anything else?
That's it,
That
Judge.
is all.